All right, I think we have everyone here. Welcome to our webinar. This is Symphonic Distribution. And Petra, if you want to introduce yourself first, and then Kayla and I can go.
Hey everyone, thank you for being here with us. I am Petra Center, the General Counsel of Symphonic.
I'm Zach Porphyris, our Director of Business and Legal Affairs. Thank you for being here.
Hi, everyone. I'm Kayla Sapiens. I'm the Rights Administration Manager here at Symphonic.
And just to get started, lawyers do have to lawyer, and you're looking at the legal team here at Symphonic, so please bear with us. This is our quick disclaimer that we're required to say, but this information is for general informational purposes only, and it does not constitute legal advice. So please do not rely upon this information without seeking your own professional legal counsel specific to your circumstances and needs. And this does not create any type of attorney-client relationship between us and you all who are attending and viewing this presentation. If you have specific questions or need assistance, we encourage you to consult with your own attorney. Thanks for bearing with us for that quick disclaimer and introduction.
Good job. We'll cover the highlights here of what we would like to talk with you about today. During our workshop, we plan to touch on the different agreements with Symphonic. We'll discuss improper activity, as we know that's a hot topic in the industry right now. And I think we've gotten some significant questions around that topic and issue through our support desk and through our social media team. So we've tried to take that information and process it and answer those questions for you here today in the presentation as best we can. Kayla's going to talk to you some more in depth about rights administration and what that means and how we approach that. We are in the process of rolling out our AI policies very soon. So we'll touch on some of that and the discussion that went into how we decided to approach that. And then we'll talk about some best practices generally to sort of tie all that together. And if there's time, cover some more questions with you.
All right, so I'll get started going over Symphonic's agreements and the different entry points for our clients. A slogan that we have here at Symphonic is that Symphonic is for everyone, and we truly do mean that. Petra, our general counsel, and I, our director of business and legal affairs, we live in the world of Symphonic contracts each and every day. It's something that we're really proud of because we do take a sense of ownership in it. We interact with our clients through our contracts, and our contracts truly do tell our story of the services that we are able to provide. Petra and I work together to build our terms and conditions that are available on our website, and we also work together to build our standard partner level agreements. We offer some more curated, customized agreements for clients who connect with Symphonic through our A&R relationships, and that's through our A&R team. Those custom agreements take more time and attention on a deal-by-deal basis. But for any of Symphonic's contracts, Petra and I, we really do live in those contracts. We're the human beings who draft them, we review them, we respond to questions about them, and we're happy to meet with you all today and also to connect with you in the future or your teams in the future if you ever have any questions outside of this webinar about our contracts. So first, to start, are our starter terms and conditions for digital distribution and other services. Those are intended for emerging artists who are building their careers, their fan bases, their monthly listeners, their streaming numbers. It's intended for artists who are first getting started. Then above that, we have our partner level agreements, which whether those are web-based through our online applications that our team review and approve, or they're customized A&R agreements that are intended for more established artists. Those custom A&R agreements may include advances, marketing budgets, or other benefits, but all of our digital distribution agreements, they include services beyond just digital distribution. That includes things like user-generated content monetization, YouTube Content ID, YouTube compositions, YouTube channel management, sound exchange and neighboring rights, SoundCloud, Bandcamp monetization, and video distribution. Those other services may live somewhere in the contract under what we call the shall provide or the may provide service sections. And what that means is that if they fall under the shall provide services, those are services that we're agreeing to provide day one after that contract is executed and after our client delivers that content to us. If it falls under a may provide service, that's a little bit different. And it means that those are other services that we may not be providing day one after the contract is signed and content is delivered, but we can provide it if the client opts in for those services for our consideration later. We include those additional offerings to avoid the need for additional agreements later. And it's really from an efficiency standpoint to give our legal team here, the three of us, and also our clients an opportunity to work with the other services that we can provide without the need to revisit negotiations later. We include all of those services in the agreement so we don't have to renegotiate an entire new deal. And we try to be as efficient as possible without taking up more of our own internal legal time, but also without requiring our clients to, again, pay their own attorneys for further review of another additional agreement or addendum later. The best way to avoid those addendums is to have all of those additional services living in the one digital distribution agreement within that one contract. So otherwise, I think some clients sometimes ask us, why are symphonic agreements so long? Well, they could be a little bit longer if they included other services like physical distribution, synchronization, licensing, and publishing administration. And those are other services that Symphonic can provide, but those require a separate agreement. Those won't be in our digital distribution contracts. But as for the length of the digital distribution agreements specifically, it's really because they cover multiple services and they reflect real discussions between legal and the other teams at Symphonic. I think Petra and I really do take pride in having detailed conversations with those key stakeholders in our business to really get under the hood and learn what they do, what their processes entail, what information they may need from our clients to be able to service that content in that way for those additional services. And then we make sure that our contract accurately tells the story of what Symphonic needs, what Symphonic does, and how the client can live up to those expectations and make this a mutually successful relationship. Otherwise, there are some notes in our contract that say that these services are up for our consideration if a client opts in later for those may provide services. And we just wanted to add some clarity about that we really reserve our right to consider those services, but we will approve them, whenever we can, because it is mutually beneficial for us to be providing those services and for our clients to have those services provided. We just need to reserve that right to check out the content for those additional services in case there's any type of issue where that service may not be applicable for the platform where that content would be delivered. Like, for instance, if there's a rights issue or someone may not have full ownership, or if the content is a cover song, or maybe there are some other things that are just not what those particular service platforms are looking for or designed for those other monetization streams. That's why we say that Symphonic will consider the client's request to turn on those may provide services when the client opts in. And then if everything is all according to plan, we'll approve it and then add on those additional services once the client opts in, and we approve it at that time. Petra or Kayla, anything y'all wanted to add about this first slide about our agreements?
I think you did a great job explaining there. And, I will just reiterate what Zach said about us really wanting to tell the story of Symphonic with these contracts. And I know that may sound silly coming from legal, but we really wanted to humanize this process, and we wanted to make sure there was a connection and a good level of explanation of, what you can expect when you read the contract. And we wanted to make it digestible, but also include enough substance that it was clear. And in order to do that, we really did sit and have one-on-one conversations with the different teams at Symphonic who handle the monetization, who handle royalties, who work with identity verification. So we've worked with all of those teams, and we'll continue to improve upon and enhance our contract drafting as things change or as we have different conversations with those teams. But truly the intention is for it to tell the story of Symphonic in the contract. And I did see a note pop up in the comment section about charging for the opt-ins. So as Zach was explaining, some of those services are already included in the digital distribution agreement. And so the terms that apply to each one of those services, those terms will be set out in the agreement. And so you'll know kind of the process there for how that service would be handled for you. and the service fees for that particular service will be included in the contract. Now, that question may be related to some additional, expedited service requests and things like that that can be handled within your Symphonic MS account. And for those, there may be one-time charges or fees related to those particular services. And hopefully I answered that question.
I do see that we have some other questions there about artificial streaming, and I just wanted to comment that we will get into that in detail later on in this presentation when we get to improper activity. So just hang tight there, and then we'll cover that shortly. Thank you. All right, Petra, you're up on this slide.
Okay, and so we tried to cover some of the general questions that we get about how we operate with our clients. And one question we get is Symphonic a record label? No, we're not the same as a record label. We are a music distributor. So some artists choose to have a record label. Not everyone needs one, but in my opinion, everyone needs a music distributor because you need the technology to get your content from you to the platforms where you can monetize it. And I think some general differences to keep in mind when you're thinking about a record label versus a music distributor. And I'm talking in generalizations because not every record label and not every music distributor works the same, but typically record labels are going to be more of a model where there may be advances attached and there is some sort of ownership component in the content that is created under that record deal for the record label. In some cases, it could be full ownership. It just depends on what the deal looks like, and that can vary by record label. But with most music distributors, they are licensing deals for a shorter term where the content is being licensed for monetization and no ownership is taken. So from Symphonic's perspective, our typical and standard deals do not include any type of ownership or acquisition transaction. It is a licensing model. And do our deals require exclusivity? We have, as Zach was explaining, multiple different types of deals that we structure with the artists and labels that we work with. And so under our starter subscription and most of our partner agreements, the client content is going to be defined as whatever the client wants to provide us for distribution. Once that content is provided to us, it is exclusive during the term to Symphonic, but at the end of the term, it would come back and be available to you for distribution or other types of licensing arrangements, or however you choose to monetize that content afterwards. But in some of our partner agreements, and that's primarily those ones with advances, it may require that the label or artist is exclusive fully to Symphonic during the term. And that usually has to do with how we define the back catalog and the new releases under the agreement. And so it really, I think, comes down to how client content is being defined in the deal. And so that's an area that you want to pay attention to when you're looking at the contract, is how is the client content defined as far as what is required to be provided to Symphonic, or whether or not you have the option to provide releases elsewhere. How long is the term of your contract with Symphonic? That will also vary by deal and deal structure. In most cases, 1 to 3 years, but sometimes it can be a little different than that. It just depends on the deal structure. Our starter subscription and most of our partner agreements are going to be in that range, but typically if we are negotiating a partner agreement through our A&R team, that structure may be a little bit different. And it could depend on whether or not there is an advance attached to the agreement. What happens if you want to take your client content down early or terminate your agreement with Symphonic? And so we understand that sometimes our clients change their mind, they may get other deals, they want to pursue other things. But we do have contract terms in place, like we just talked about how we define the client content and the length of the term. And so you may still be in term with Symphonic, and we may have to have a conversation about that. And so the best thing to do is reach out to support, and they can route those questions to legal if it needs to get to that point. But typically just paying attention to the way the client content is defined and what the length of your term is in the contract is the best way to understand what your obligations are there. And so there may be situations where Symphonic would make an exception or may negotiate an early release there, but it really just depends on the situation.
There's one other note I wanted to add here, where we do have a lot of clients or potential new clients ask us if we can consider their red lines or their requested revisions to a new deal that we might be working on. And, generally, I would comment that every deal at Symphonic is unique. Certain deals are custom, but others do remain within our standard templates without as much customization. We do try to customize or consider red lines to the furthest extent that we're able to do so, but we're just not able to customize or accept red lines on every deal that comes across our desk. Just given some of these practicalities and also the scale at which we operate and the size of our legal team. The lawyers within Symphonic are here on this webinar today. It's me, Petra, and Kayla. Escalating every deal to custom contracts for us to review red lines just wouldn't be practicable given the scale at which we operate and the time and cost that would incur, which ultimately wouldn't benefit all of our clients. This certainly doesn't diminish how excited we are to work with every client that comes to Symphonic, and generally we'll do the best we can to answer any questions, even if we can't accept red lines on every single deal. I don't know if Petra, you have anything else that you want to add about that?
No, just on the red lines comment there, it also has to do with, from an administrative perspective, we have a good many clients, and so keeping things sort of uniform and consistent so that our internal team is not having to track lots of different exceptions and things that we're not set up to do that have to be one-offs that require more human oversight than what we already have. We would prefer to focus that attention on just giving other good services to our clients. And so we try not to make many exceptions there. And like we said, we worked really hard to make sure our contract reflects sort of how we handle things and what our teams do. And so if we make changes to those things, then we've kind of gotten off track. I also saw here in the chat box if we offer artist development or management services. And, we have a great support staff, and we have just a really, great resources on our website. And we offer marketing in certain situations depending on the structure of the deal. We don't do per se artist development services, but we do offer lots of other types of support to our clients.
All right. And for other questions that are coming in on the chat, we will take a look at those. And if we don't address them all as we're delivering this presentation, we'll reserve some time at the end to answer those that we can. All right, Kayla, I think you're up with this slide.
Yeah. So we wanted to go over what clients need really to get started with Symphonic and to distribute with their music with Symphonic. And one of the first and most important requirements is that you need to be the rights holder or the owner of the content you wish to distribute. So you should be either the sole owner or have authority to distribute all content that you want to upload to your account. It's imperative that you're the rights holder, and upon applying to your account and signing up with us, you're making representations and warranties to Symphonic regarding the content that you are controlling. Once you sign up and apply, this application will then be considered for approval by one of Symphonic's team members. It's really important to know not all applications are approved, and this can be for various reasons. Sometimes, there are corrections that need to be made or more information is needed on our end. But once an application is approved, you will then be prompted to agree to our starter terms and conditions or execute the digital distribution agreement, depending on what avenue you have chosen to join Symphonic with. All clients, once approved, will also need to complete identity verification and provide information for our payment processor. Zach, is there any other information you want to add there?
No, I think you covered it, and we're good there. And then, Petra, if you want to address that second question on the slide.
Yeah. So if you're back to what Zach said about symphonic being for everyone, we really want to be on this journey through the long haul with our clients. And so if you start with us as an emerging artist and you're starting to gain traction and maybe you want to talk about a more robust deal with symphonic, then those avenues are available. And we've talked about the different avenues and different approaches to our deal structures. And so our team is also looking out for that. They're looking for emerging artists who are following a structured release cycle, growing their numbers and things like that. So we're looking at that internally as well. And we encourage our clients to reach out as well when they feel like they're reaching those thresholds and maybe they need more support, or they're looking to do a different type of deal structure where maybe their catalog supports consideration of advance or other types of services with us. We always encourage clients to reach out about that.
And we also have a team internally that will review that and see if a client is on the right opportunity and might be a good fit to advance to the next level of a symphonic contract. So you might hear from us on that too. We have an A&R team that might reach out about renewing a deal for different circumstances. So you're always welcome to reach out to us at support, or we may reach out to you. And then for the third question on the slide, what if I have back catalog and distribution with one or more distributors that I want to distribute under a distribution agreement with Symphonic? Like the slide says, you should review your existing agreements or terms and conditions with other distributors and pay close attention to the terms section and any actions that are required of you to move your content. So it's not uncommon for artists or labels to move distributors. But we do have the expectation that if an artist or a label is coming to Symphonic, moving their back catalog over from another distributor to us, that they have cleared that with their prior distributor. It's important to us and for our relationships with our competitors that we honor and are respectful of our competitors in the market. We do want to help facilitate the movement of catalogs between distributors if that's what clients choose to do. But we do have to be mindful about what contract terms say about making those changes. If it's not done correctly, it can really be a hindrance. For example, if a new client comes here to Symphonic, pays their legal team, goes through the process of signing a contract with Symphonic, and then at the end of the day, that's all to find out that they're in terms somewhere else, and there are more hurdles to clear that catalog. We just don't want to see our clients, our new clients who are excited to start this relationship with us, do all of this work and pay these legal fees on their end without a solid end result. It's important to know what the terms are of the deal that you signed. What needs to happen? Is there notice that you need to provide to your prior distributor in order to take your content down there at the end of the term? Really look at those contracts and see what the term requirements are and what the notice requirements are to make sure that you've done what you need to do, what needs to happen in order for them to allow you to move your content over to Symphonic. There are some apps that can help you track that information if you research that. But at the end of the day, we do try to have friendly relationships with our competitors. And if these questions ever do come up, our content team and us as the legal team will work together with other distributors to make sure it's a nice transition without any loss of data or analytics. But the contract terms and whatever contract you've signed with your prior distributor does come first, and those contracts do control. So if you're still in term at another distributor, that other distributor may not allow you to just take the content down. All distributors are different as to what they may say about the term, what's required to end the term, to end the exclusivity requirements at that prior distributor, and what the other requirements of their contract may say. So make sure that you take a look at that prior contract. And if you have questions about it, we recommend that you consult with your own attorney to make sure that it will be a smooth transition for you.
Okay, and I want to say I appreciate how engaged this audience is. There's some great questions popping up in the chat box, and we'll continue to try to field and grab those and weave them in. Some of this we're covering on later slides, and so I don't want to hold us up too much, but someone asked about what is the threshold for changing or updating to a more robust deal with Symphonic, and I don't think there's any like surefire threshold there that we could focus on. I think it really just depends, you know, on the particular artist or label and where they are with their metrics and analytics. And at any time, like Zach said, you know, it may be us reaching out to the artist to find out more about what they have going on. It may be the artist reaching out to us, you know, talking about what they have worked on and what new releases they have coming down the pipeline, where a different deal structure might make sense. And so those avenues are open. There isn't one specific threshold. Someone else also put in a great question here about what would happen to Symphonic as Merlin members with the upcoming change with TikTok. We will continue to deliver content to TikTok. We have entered a direct deal with TikTok, and while we wish that things could have worked out differently there, we want to be sure that we can continue to provide that service to our clients. It's our understanding, you know, that our clients want to continue to monetize their music on that platform. And first and foremost, that is always going to be Symphonic's top priority, is to our clients. And we want to have great relationships with any DSP we're working directly with. And we very much value our relationship with Merlin. So the content will continue to be delivered to TikTok, to answer that question.
There are some other questions here, more about artificial streaming and streaming fraud, and I promise that we'll get into that shortly. We have some slides built out for that. And then also there are some questions about publishing services and sync services. This presentation is focused more so on our digital distribution agreements, which cover digital distribution and those other services that I listed. Symphonic does offer publishing related services, publishing administration, and some others, and then also sync services through Bodega Sync. But those are separate agreements through separate applications first only. So this presentation really isn't geared towards those services, and those would live outside of the digital distribution agreements that we're focusing on today.
Okay.
All right, improper activity. So we're getting into the world of artificial streaming, copyright issues, and everything that y'all are asking about. So good timing. All right, Petra, you are up with this first improper activity slide.
So I've said a few different times that I really had no idea when I came to work at Symphonic about 2 years ago as general counsel that a good portion of my day, almost every day, would have to do with the subject of improper activity. But I feel like I, you know, joined the company around the time where this was, you know, hitting critical stage industry wide. And I feel like there's just been so much that's happened over the last 2 years. And it's really important, I think, in addressing these questions to just think about the state of the industry generally. Many of the DSPs are now adding their own trust and safety teams, and there's dialogue between our trust and safety team and our legal team and the trust and safety teams with the DSPs, and the policies are continuing to evolve and the communication is getting better as we move through that process. And so I think that's kind of the backdrop, is that sometimes things move so quickly that the rest of, you know, the business has to catch up with it. And so I feel like we're starting to reach a little bit of a stride where we're getting more information from each DSP, but I think there's still, you know, questions that we have, questions that our clients have, and we are, I assure you, spending a lot of time on this behind the scenes and trying to make sure we do a good job of communicating with our DSPs and understanding, you know, their content guidelines and their expectations, so we can carry that back to our clients and be educational and help them to understand so that they can also be compliant. And I guess that's kind of the backdrop of the improper activity discussion. So we call it improper activity because it houses quite a few different things. That can be artificial streaming, manipulating streams using bots, direct or indirect infringement on copyright or other IP rights, non-compliance or circumvention of policies by Symphonic or the DSP regulations that we were talking about, It can include things like bank fraud or any other type of fraudulent activity. And so we have taken care to try to define this as best we can with what we know in our digital distribution agreements and other symphonic contracts, to try to point out all the different avenues and ways and things that we have to be concerned about in our partnerships with the DSPs and in our partnerships with our clients. One of the questions that we get frequently, is just broadly, how are the DSPs addressing this? And I can say that, our team working very closely with this, that it varies by DSP. They all have different avenues and different mechanisms. Some use third parties to help them to detect different types of improper activity on their platforms. We're not fully privy to all those details. And we deliver to over 200 DSPs to monetize our clients' content. So there are a lot of different potential policies and processes for us to try to learn about and keep up with, so we can keep our clients informed and be good partners there as well. So they have pretty broad remedies, each of the DSPs, as far as what they can do if they detect that improper activity is happening. And that can include things like blocking or taking down content, refusing to accept further content from that artist or from that label. They can withhold payment of royalties. They can terminate the service, demand repayment of past royalties, issue penalty fees, require indemnity of any cost or fees that they incur as a result of the improper activity or other remedies. And like I said, we try to explain that very broadly, because delivering to that many different service providers, it's a lot to cover. And so we try to be as broad as we possibly can, because we owe those same representations and warranties to them that our clients owe to us. And I hope that that just kind of broadly paints the picture of, all the different things that we have to think about and monitor on our end. So sometimes we get questions from clients that are a little more specific and targeted. My analytics show more streams than I receive payment for. Why is that? Well, that could be because that particular DSP, and not calling out any particular one, because like I said, they're all different, but that could mean that the streams were still included in the analytics that were reported, but the royalties were not paid through. And so you may see more stream count than what you're paid for, because a different decision was made about those particular streams. And so, again, all DSPs are very different in how they approach that, and we don't necessarily have, control or a say over how that's counted. Why did I receive a penalty fee on my royalty statement? So some DSPs reserve the right to charge penalty fees to the distributor. So that penalty fee would be assessed to Symphonic if there was improper activity, such as artificial streaming, on that account. And so under the terms of our digital distribution agreements with our clients, we retain the right to pass on indemnity of cost and expenses that Symphonic incurs. And so sometimes those penalty fees may be passed on to the client if they are assessed against Symphonic for activity that the client was flagged with engaging. I'm going to take a peek. Zach, if you have, or Kayla, if you have anything to add there, I'm taking a peek through the chat box.
Yeah, I do think some of these questions in the chat will be addressed in more detail when we get to the artificial streaming slide specifically. I think we're good to move to the next slide. All right, so improper activity and how Symphonic addresses it. Two key areas of improper activity are artificial streaming and copyright or other rights infringement. For artificial streaming, one tool that is really helpful for our clients that we recently rolled out is called StreamSafe. It supplies a collection of analytics from multiple DSPs from the reports that they provide us regarding artificial streams. It's a feature that not many of our competitors are offering, and it's available directly in our client's Symphonic account. It gets updated as soon as we get those reports from DSPs, so our clients can see that in real live time and the same cadency that we are receiving that information. Our team also notifies and educates clients if the DSPs provide us notification outside of those reports, or if our team internally flags something that may be involved in streaming fraud or artificial streaming based off of the data and analytics that we review internally on our own. Those notifications are tracked internally to ensure that our clients become compliant. And then we will remove or block content if it is above our artificial streaming thresholds. And we may potentially need to block off royalties. Those egregious violations or repeated violations can result in termination. But I think the most important piece here is that if a client sees something strange or off-putting in StreamSafe, or if they receive those first educational notices from us, we do encourage our clients to look at what's going on, see if their music and their content has been added to a playlist that they didn't request that looks fishy. See if there is some strike in streams after maybe they signed up for some marketing opportunity that was inadvertent and they didn't realize that was signing up their own content for streaming fraud and things like that. But the real reason why we do that notification is to educate our clients on what's going on and to provide our clients an opportunity to respond and work together with us to collaborate, discover the issue, and remedy that as quickly as possible. We really just need our clients to answer and to work with us when we do reach out with those educational notices so that we can potentially raise those issues to the DSPs if it warrants doing so. But if our clients don't respond to us and don't collaborate with us with that information, we really don't have much to go off of. And we'll get into more detail on the next slides about that as well. And then for infringement, if Symphonic does not receive a response to an infringement claim or the response supplied is insufficient, we may remove the client content or block it. We can block payment of royalties, or we can invoke other remedies that are set out in the digital distribution agreements. If there's ever court litigation related to the infringement, Symphonic will likely block royalties at the account level and will require your assistance with providing discovery or other information as needed until that gets resolved. If there are egregious violations or repeated violations, that can result in a termination. And if you have specific questions, I encourage you to check your agreement. It's likely Section 9 if you're on one of our newer agreements for more information on these remedies. And there's also other sections about indemnification, like Petra mentioned.
And I'll throw a sprinkle in some questions there from the chat box. If there's a way to go back and correct this once you've been flagged for it, is there a way to get off botted playlists? Some other questions around what can I do if I'm flagged for this? And like Zach was saying, I think the best thing you can do is respond when you get these notices. And try to provide any information that would be helpful. The botted playlist question, we just had one recently come up where a client immediately saw, when they saw the spike in the streams from getting added to a playlist, they reached out the same day. They were monitoring their numbers that closely. Kayla, I believe, was the one who flagged that to the DSP. They checked into it, and in that particular scenario, I think that worked itself out in a way that was appropriate. We can't guarantee that will be every situation, but we can't do anything. We can't pass on any information if we don't have it. And so Kayla does a great job of tracking that information because it's her and Jeremy, who's on her team, who are sending out all these notifications when they go through these streaming reports every month and trying to be educational, trying to let clients know what's happening so they can prepare for it and provide information in return. And so we're trying to be collaborative on that. We know that there are questions and that it can be frustrating for those of you too who are not intentionally doing bad acting or intentionally artificial streaming. There may be confusions or questions around that. And the best thing we can say is communicate back to us about why you think this happened or what the issues were, or what you're seeing. Again, we're only a team of 4 people here handling this stuff. Jeremy's not on the call, but we'll do the best we can to review that information and at least collect it where Kayla's tracking it and see, if we're hearing similar things back from, a high volume of clients. That might be one that we could flag up to that DSP, and it could make a difference.
All right, copyright and rights claims. Kayla, you're up.
Yes, thank you, Zach. So this is a very common question we get is, what is a claim? And to put it simply, a claim is an assertion that your client content infringes upon third-party intellectual property rights. And these can include copyright, trademark, and name, image, and likeness rights. Claims can be against different aspects or parts of your client content, such as the sound recording, composition, and artwork, among others. Most often, though, a claim will involve the sound recording. That's what we see a lot. When Symphonic receives a claim, we will promptly notify the client whose content is affected, and that we will typically send out this notice within the day. Claims can be submitted to Symphonic via DSP, which means the claimant will go to a DSP such as Spotify or Apple Music and inform them, who then informs us in turn, or the claimant will directly notify us. Our claim notices are then sent to the clients and provide detailed information regarding the content, where the claim is from, and what actions may have already been taken if the claim was sent to a DSP. So then the next part is, what do you do if you receive a claim? And the claim notice that you receive will have some pretty detailed next steps that we will need you to take to address. The most important part is that we will ask for some documentation of rights and a counter notice and reaffirmation of indemnity within a specific window of time. Every document provided by you to us is reviewed by our team, and we do read through these pretty in depth, and we try to really take everything that is submitted to us into consideration as we address these claims. And we will also provide other instructions, like what type of documentation could be helpful here and what also may happen once we get that. Anything else you guys want to add to this slide?
And I can't remember if we get into this on the next slide or not, but I just wanted to talk about why these claims are so important. And I know that sometimes this gets frustrating for our clients too, because they feel like they are being targeted by someone else, maybe one of their competitors, maybe, who knows, but, it's important because those things have the ability to escalate to something much larger. And so, I think, when we've talked a lot about indemnity today, and I think it's important to focus on that as a little bit of a topic here, just because, if you look at some of the lawsuits in the industry over copyright issues, usually they're big splashy headlines and very large judgment amounts. And so that's, one of the reasons why, for your sake and ours, we have to be careful about this, because we never know which one of these things is the one that makes that escalation up. And as lawyers, we're always thinking about the fact that whether we're right or wrong, there's probably going to be some cost attached to it if there's an escalation. So we have to think about it on both sides of the equation, not just if we think we're right, but how much is it going to cost us to prove that we're right? Because we also owe indemnity up the chain to DSPs and other, places where we monetize our clients' content. And our clients in turn owe that indemnity up to us. And so we're all taking a big risk that, a DSP has an action against them for content that we supply if we don't get this right. So it's really important that we get this right. We want to help our clients so much get their music out there and be visible and be heard and be able to monetize it and have as much of a revenue stream from it as they possibly can. But we have to be, mindful of the guardrails around that and not taking chances.
Okay, so another very common question we get in regards to our rights claims is, I responded to the claim. Why is my client content taken down anyway? And there can be multiple reasons for this, but a big one is some DSPs will immediately remove the client content upon receipt of a claim, and they will not reinstate without retraction from the claimant. This is an internal policy that multiple DSPs have that we unfortunately cannot control. They make their own decisions regarding, their risk and assessment to rights claims, and unfortunately, we all just have to play in that space there. If you do not respond in the time frame required or a response is inadequate, Symphonic may necessarily have to remove the client content, as we just don't have enough information regarding that specific claim. So what does Symphonic do with the documentation that you provide us in response to a claim? The first thing we will do is we will review everything that is sent to us and save the information for our records. Like a counter notice and reaffirmation of indemnity may be provided to a third-party claimant when it is appropriate to do so to assert rights there. But the most important thing is this is something we take very seriously, and we really do consider everything that is sent to us, and pretty in-depth as well. So we want to make sure our clients are really getting the most fair treatment possible in regards to these claims.
Yeah, and it is a volume that I want to just shout out Kayla here. It is a volume of information coming at her and Jeremy on a regular basis. So it's a lot for them to review. And they try to carefully review everything our clients send.
Thank you. So responding to claims, this is also another big questions we get is like, what can a client do to, show they own this content? Because many times we have clients say, I'm the owner. What documentation can I give you? So we put here some best practices and possibilities that every client can take to make sure they are doing the best to, protect their work. And the first one we have here, you can register your works. We always recommend keep documents, including all detailed records of the creation process, embed metadata and watermarks into your work. Also very important, you preserve the original files. That is great to have a chain of title, a chain of record. Digital forensics can also be employed if you you're able to get those sort of tools. And musicologists and witnesses to your creation process as well these are all things, some of these for a worst case scenario, but every step that you take to protect your music is really important. Also here is sufficient documentation to assert rights. There are different documentation that we can consider in response to a rights claim. Some of the common ones that we will, get or tell people that can be used, but include but are not limited to contracts, label waivers, artist agreements, work for hire agreements, particularly if there's a featured artist issue or a dispute over a featured artist, songwriter splits, licenses from the rights holder or original creator, and copyright registrations with the appropriate governing authority. It's really important that you are mindful over what is included in the documentation you send for review. And generally, you want to make sure you know what terms are included there and what these documents are doing for you. We would always recommend any third party or any contract, any documentation you have, carefully review it with an attorney, which is such a boring thing for us lawyers to say, but it is very important because they can tell you whether or not this document is working for you and it is doing what you need it to do, which is, protecting your music, protecting your rights. So it's always good to have somebody else look over that, a legal authority to look over that and make sure they explain to you every single term.
Yeah, because if it's not, if it doesn't say what you need it to say and it's not executed correctly, it won't help you in the way that it needs to. And so it's just, I mean, we get it, coming from artist management space, it's not a sexy thing to do to walk into a write or studio session and talk about split sheets and things like that. But when it comes down to the difference in being able to have your creation out there or not, or if you get held up because there's some sort of rights conflict, we feel terrible about that when it happens. But in most cases, we can't stop it. If there's some sort of conflict, like Kayla was explaining, that causes the content to be taken down from DSPs while the conflict is being resolved, that's not what you want to happen after you've put all of your hard work into it, probably did some type of release plan or promotion around it. You want to be sure that everything is right before that release happens.
One other thing I'd add here is that, there's an element of this which is out of our control. if the DSPs receive a claim directly and have already taken the content down. They, in most cases, will not restore that content until there is a retraction by the claimant who submitted the claim to that DSP. So even if you do have all of your documents in a row and everything says what it needs to say, and we maybe make a judgment call and agree that there is a proper assertion of those rights based off of that documentation, we can help you potentially submit that to the DSPs, but it's really going to be up to that claimant to do the right thing and to retract their claim. And a lot of DSPs will require that last step before they'll restore the content.
And very important, Kayla, can you repeat the address for dealing with copyright issues?
Yes, if you've received a claim from us or need to contact us for a copyright issue, you can contact us at copyright@symdistro.com. I can also repeat here, I think it's in one of our slides, if there's an improper activity or artificial streaming, we have another avenue to contact us, and that will be trustandSafety@symdistro.com.
And very important, please don't ignore notices from those email addresses. If it's the SOS from us saying, please, we need to hear from you because there's an issue.
Yeah. And if there's a question of if you received it from us, like if you're not sure it's actually from us, reach out to those emails, copyright@symdistro, and we will be able to verify if we sent you a notice or that was from us.
That trust and safety at Symdistro, that is a great email to send if you catch that there's something up with your music, or you see something on StreamSafe, or you see that your music has been added to a playlist which you believe is botted, that was out of your control and you didn't ask for that and you want to let us know. That's a great email to send that information to.
Yes, we do monitor all replies and emails that are sent there, and there's a high volume, but we do try to get back to everybody.
Kayla, can you repeat those two email addresses one more time? Someone just asked in the chat.
Sure. For copyright and rights issues, it will be copyright@symdistro.com. And for artificial streaming or other improper activity issues, it will be trustandSafety@symdistro.com. And I thank you, Zach, for typing those out.
All right.
And I think we can just kind of, we can walk through these, I think, pretty quickly, because I feel like, Kayla, you covered some of this on your last slide too.
Yeah, I think this was a good summary slide. If Kayla, you just want to maybe read through this one time, and then we'll move on to some commonly asked rights questions.
Yes, totally. So yeah, really to recap most of what we went through, what happens if I do not reply to a claim or my response is deemed insufficient? If Symphonic does not receive a response within the requested time frame, like we may proceed with taking down that client content from all DSPs. We may also withhold or retain royalties generated by that client content or other remedies as set forth within the digital distribution agreement or our terms of use. And this really is important, has to do with keeping Symphonic safe and also covering any liabilities that may arise. Symphonic will review retractions or other resolutions of rights issues for possible reinstatement. We will make sure if we receive a retraction, we do notify all clients, and we try to make sure we will get in touch with the DSP and ensure they received it as well. But, it's really on top of the client to make sure they're seeing all these notices and keeping us informed as well.
And that works both ways. If we could pause there for 1 second, Kayla. So if you resolve a rights claim outside of us, if you reach a settlement agreement, or if the claimant retracts directly to you, then you can let us know that and provide that information. And the claimant can send us, their retraction, or you can give us a copy of the judgment or settlement, and that can be considered. So we won't always have that information. It won't always be coming directly to us. But if the client gets it, then they can bring it to our attention.
Yes. And if a claimant sent it to a DSP will usually confirm with us as well. That's important to note. So please, if there's an update that we haven't been notified, make sure you write back into copyright. Will you inform me when my client content is removed? We try to provide notice of the actions we are taking on all client content, whether that is for improper activity or copyright, different issues. We will send notices. We are pretty good at getting those notices out pretty quickly and timely. and you should be informed. If there was no notice from us, always write in if you have a question about what is happening to your client content. Sometimes that is just other DSPs taking them down for different reasons that we weren't notified of yet. Should I register my works? It can always be helpful to have proof of rights and enforcement of rights if you have registered your work. Again, always important to note, we can't provide legal advice here, and copyright laws and processes do vary by country. You should really consult with a registered attorney in your country or territory to see what they advise as to registration and what registration protections would be given to you if you registered with the governing authority there. What should I do if my original work has been stolen or infringed? This is a really important one. It is the responsibility of the rights holder to enforce their rights. Symphonic is not a rights holder, so we are not in a position to be able to enforce rights for anybody. We can maybe guide you to the right direction, but we are not an attorney. We're not your law firm. It's very important that you enforce your own rights. If you wish to file a DMCA, you can contact the DSP or other provider where the work is being infringed upon. You can communicate with the infringing party to resolve or work with a lawyer to escalate the matter and pursue other remedies. It goes without saying, we always recommend you consult an experienced attorney if you have questions about protecting your rights, because it can be very complicated when you're distributing at a worldwide scale.
All right, are we good with this slide?
I think so.
All right. So some commonly asked rights questions. First, what do our viewers need to know about cover songs? Kayla, if you want to take that one.
Sure. So the number one thing with cover songs is check your DSP requirements. DSP requirements for cover songs have changed pretty within the last couple of years. So you really want to make sure you know like what they're accepting, what they're not, and DSP requirements are usually available online. You also want to make sure every cover song you distribute is properly licensed, and this may include getting a mechanical license. And it's really important to note you really work to get these licenses beforehand, because if there's any issues on the back end or after you distribute, you can lose your momentum. And we want to avoid DSPs taking action on your client content, and we want to make sure your content is available to your your listeners. So really important that you make sure everything's properly licensed.
All right. And how about public domain works, Petra?
Oh, I love that I get called on for that. I think that this area is a lot more complicated than people think it is. I think that, it's a legal argument that we've heard come up quite often. But the reality is you have to be very careful about it. It only applies in certain areas. It's only, for the particular version of that content that has fallen into the public domain and no other versions of it. It's hard to sometimes know that, I think. And, there are various other little red flags and pitfalls that can happen there when you're trying to work with public domain works. And it's really just not as simple and straightforward, I think, as you might think that it is. And so really, again, when it's not your original work, when it's not something that was, created by you, anytime you step outside of that zone, there can be just pitfalls and things to deal with where, I know we keep reverting back to maybe consult a lawyer, but consulting a lawyer in an economical, efficient way up front to understand what the issues are before something becomes a liability and an escalation for you down the road is really the best avenue to go. Because if the result of that conversation is, oh, I can't do what I wanted to do there, then and you don't move on, and you can just go create otherwise or find other, content to create. But I think it's just important to understand that sometimes things may seem simple, but IP rights are a very complicated area, and you want to be sure that you're getting good advice about it.
Yeah, and I think the same goes for remixes. If that is a derivative work of someone else's original content that might not be yours. Again, it's just making sure that you have those proper licenses for that derivative work. And again, for anything related to cover songs, public domain, remixes, or any use of someone else's content, It's just so important, especially as our clients are trying to build their reputation and build their fan base. There's all this effort on release schedules and the promotion of new content. If all of this isn't done properly and a track has to come down later after the fact, that really is a halting stop to the momentum that our clients work so hard to build. So we recommend that you consult with an attorney as you're building your music, as you're getting ready to release it, especially if you plan on working on cover songs or relying on any type of public domain argument or making any type of remix. Anything else before we get into some of these other questions?
I think a lot of these questions are going to have the same answer, which is do your homework on the front end, and make sure that you have the proper rights and clearances. And anytime you're using somebody else's music, you're sampling them, you're trying to use their image, which these questions touch on those various topics, you're going to likely need rights and clearances from them or from their label, in order to do what you're trying to do. So I think if you just want to read through those, then if there's anything particular about that, that we think they need to consider additionally, we can get into.
Yeah, I think, Petra, you've covered the first one. As for using someone else's music with lyrics, we're seeing that this is coming up more frequently now, especially with the evolution of AI and tools that are making it easier to do that. In those situations, if something isn't cleared or authorized, then it could be a derivative work without a proper license. As far as using images from famous movies, TV shows, books, or other popular art as cover art for music or for videos, again, that could infringe upon someone else's rights, but that might even extend into infringing upon their trademark, to their right to publicity. So again, it's just important to make sure that those rights are secured and that you've covered all of the uses that you intend to use that work that you're sampling or that work that you're pulling from, so that you're not surprised by any claims after your music takes off and it starts performing really well. I think this question comes up more often than not. I might be skipping ahead, but the question here about licensed beats or loops that come from other websites. So I don't know if Paige, you want to hit that one.
I will. I think that one comes up pretty frequently because I know that a lot of artists tend to use those as sort of the foundation for their creation. And what that can do, we talked earlier about the different types and avenues of monetization. From if it's a non-exclusive beat and it's used on multiple sites by multiple artists, that's going to create ownership conflicts and rights overlaps in UGC monetization. And so there may be certain avenues for monetization that just won't be available, depending on what type of content was used there. So that, we just really encourage when you're signing these licenses to understand the nuances of the license and make sure you're checking. Sometimes they have a cap on streams, but maybe you can't get above 500 streams with that particular beat. And it's really on the client. It's the burden of the client making the representations and warranties to Symphonic that they have the right and authority to distribute this music. If they've used a licensed beat that is non-exclusive or has any type of limitations on the usage, that it's going to likely create issues in the distribution of that content that, again, we won't have control over. It just may not be appropriate for certain DSPs.
And for that last question there about collaborations with producers or other artists and whether or not our clients can distribute that content, it's just, again, so important that if you do work with collaborators, that you have either proper licenses or that you have those split sheets in place from the start, and that you have those authorities documented from the collaborators on the track with you. Those necessary splits for any royalty distribution between the parties really should be established at the phase of working on that content and creating it in the studio or wherever you're creating it in the first place. And then all of that really, needs to be complied with once you do upload the metadata and you do credit the appropriate collaborators on that music, and that those splits are applied properly as the royalties start coming in. We do offer a really great tool called Split Share, where our clients can go into their Symphonic management system accounts and set up Split Share so that as royalties start coming in and are processed for that music and posted to our clients' accounts where they can request those payments, that those splits are already actioned according to the percentages in the split share that were set up on the front end, so that once those are established and filled in, it's a bit hands-off after that, and our clients don't have to worry as much about it because it's already established and calculated for them using the split share tool based off of the information they inputted on the front end.
And, just we'll continue to go back to making sure this is agreed upon on the front end, because sometimes when there's a collaboration or a feature, there's different perception about how those things will be displayed with DSPs and who will be, whether it's a feature artist or some other arrangement, or even with working with producers, if that's not all worked out on the front end as far as the rights and splits on that content, that can come back and be very problematic once the content is up, and it may have to come down until any disputes are resolved. And that's really not what you want, is to put it out and then lose the momentum by having to take it back down and then go back, because you start to lose leverage in negotiating those resolutions at that point once the content has already gone up. And then you have to revisit with a feature artist or a producer who knows that, they sort of have the upper hand there for, because you want to get that content back up as soon as possible. So it's really just best to work that out on the front end before the content gets released.
All right, catalog integrity. Is your content compliant? All right, and Petra, you're up with this slide.
So catalog integrity, I think, is a really good phrase for just being a good auditor of the catalog that you're submitting, and knowing what's in it, that all the rights are lined up, that you have all of your information ready to go if there's any issue or any question that you're, like the client example we gave earlier, when they saw the spike in their streams on the very day that it happened. That's how closely that, some of our clients are doing such an excellent job of just really staying on top of things, having everything documented, accounted for, watching their numbers and knowing when to reach out with us. And that makes our jobs and our lives easier when our clients are meeting us halfway and doing those things with us as well. The first question here, how can you monitor your streaming activity? And I saw in the chat box someone was asking about StreamSafe, and that's something that we had mentioned earlier. It's an analytics tool that our product and tech team has come up with. They're constantly working to figure out how to update our analytics and give additional features to our clients who can that can help them navigate these difficult issues. But this allows you to monitor the reported artificial streams and playlist activity across the multiple different DSP reports that we get. So they're ingesting that and then generating reports and stats that our clients can go into their Symphonic MS account and monitor on a regular basis. And let's see here. Can I use independent marketing companies to market my music? I think that was also a question in the chat box where someone was having a communication with their manager about using independent marketing companies. I would say to pay really, really close attention to the various DSPs and their content regulations and what they require, because Spotify particularly prohibits the use of third parties who guarantee streams or guarantee playlist placements. And the reason for this, I think, is just over time, and this has been identified in the chat box here, there are just issues that, result from that unintentionally sometimes on our clients' part, where they think they're paying for a marketing service, but it ends up being improper activity. And I think Spotify and other DSPs have, included this in their regulations and content guidelines, just to try to cut back on that. And we don't ever want to see a client being, taken advantage of or paying for marketing that somehow jeopardizes their hard work on their content. And so if there's any question about it, if you feel like the representations that are being made are on the line, just think really long and hard about that. We don't say one way or the other, you should do this or you shouldn't do that, but the DSPs may have their own particular regulations about this that you have to comply with. And you just want to make sure that you're not violating any of those, because the whole point is to get your content more visible and not to have it taken down. What should I do if I notice any unusual activity connected to my client content? And we talked about this. We put the trust and safety email address in the chat box as well. Please reach out to us and let us know, especially if you get a notice from us that anything has been flagged as an improper activity on your account. The more information that you can share with us, the more that we may be able to help you to deal with the issue, or at least at the minimum, we can collect certain information that our clients are giving us to take it back through to our DSP connections.
All right, Mila, if you want to take this last slide on catalog integrity, and then I think I have one more slide, and then we can try to answer a few more questions.
Sure. So have you audited your catalog? So we really recommend you take the time to ensure you carefully review and document all important information about your song catalog. This would include, artists, contributors, and collaborators. This is very important to always have that information on hand. And again, this is useful for many reasons. You would need this for contracting, ensuring you can prove and enforce your rights as needed, checking to be sure that you do not have any uncleared issues that could cause your music to be taken down or for you to incur liability, and can be done in a simple spreadsheet or using an app for tracking splits, metadata, and other important information. And again, this just goes back to what we discussed before, making sure you always know what documents you have and the terms of those documents. It's really important for protecting your rights and protecting your music. What are some of Symphonic's tools for ensuring catalog integrity? We actually really do offer a lot in our platform. Of course, we have our clients' representations and warranties of rights and indemnification. We have a full content team that reviews and reviews submissions, as well as technology, which scans the content. Our content team will look for matches against existing data and other red flags that could indicate possible rights overlaps and other issues. Oftentimes, when we do have some questions, they will flag it and ask the clients to proactively give us some documentation to review before we even delivered the content to DSPs. And particularly if there's, a high profile artist or a curated artist, those would be flagged by a DSP. So we will often take a careful eye to content like that. Our UGC and video teams also separately review content that is being delivered to those platforms as well to make sure they are compliant with those terms. And of course, the number one thing is the client being diligent about what they are providing to Symphonic to deliver, ensuring it meets all the DSP requirements for the DSPs that they are choosing to deliver to.
And one other thing I'd point out about all of that too is the earlier the content gets to our team to review after the submission, between the submission and the release date, the better, because the more time there is to deal with any issues that might come up.
Artificial intelligence. So can our clients distribute AI-generated content through Symphonic? We are implementing new policies now, and these policies will be updated and evolve over time as additional laws and guidance come out. You can review copyright guidance on the U.S. Copyright Office's website, but please be mindful that certain states, as well as international territories such as the EU, have enacted policies and regulations that may affect AI usage that you should stay informed about. Symphonic will be providing an interface within the Symphonic management system, which allows for the following disclosures as related to client content. It will ask, was AI used for audio, lyrics, and/or artwork? Was AI partially or fully generated for the music? So was that music created using partial AI or full AI in the generation of that content? Which AI tools were used? And then this information will be tagged and tracked within Symphonic's system specific to that content. Symphonic prohibits content that may be a sound-alike, that may be an impersonation, that may infringe upon copyright, name, image, likeness, trademark, or other rights, or any content that is related to or committing any other type of improper activity. We do monitor the volume of deliveries and the metadata associated with those deliveries and any other suspicious activities within accounts. So even if something is, AI or not AI generated, if it is still a sound-alike, an impersonation, infringing in some other way, or related to some other type of improper activity, then it's still improper activity, regardless of whether or not it is AI generated.
Yeah, so some of those already, it overlaps with other things that we would be looking and checking for on the front end about rights issues as well, whether it includes any AI component or not. But I think the biggest disclaimer here is, we're still in the process of reviewing and implementing some of this, and working very closely with other lawyers and talking with others in the distribution space, and just trying to keep a good handle on the evolution of this in the industry so that we can be cutting edge and we can have good communication with our clients about expectations, about any DSP expectations that we become aware of, and just stay current with the laws and regulations as they evolve. And I think one other important note there is that it's, the clients must be diligent on their own, because the expectation is that we're all keeping up with this as things are changing and evolving.
All right. Do we want to spend some time just scrolling through these questions to see if there's any that we haven't answered that we might be able to quickly hear?
Let's see here. Some of you all went, appreciate you being so engaged here and sending us some of the fact patterns are a little bit longer. And I can tell from some of them that there are some frustrations. I feel like a lot of the feedback that we've gotten here is on the topic of artificial streaming. And we've tried to share as much knowledge and information as we have and about our processes, but also what the DSPs expect of us within this process too during our chat today. And we may need to collect some of these questions and maybe even schedule another one of these just on the topic of artificial streaming, depending on if the feedback that we get here and if there's still other outstanding questions. But I feel like we covered as much as we can on that topic here. And I think we answered a good many of these artificial streaming questions during our presentation.
There is one question here unrelated to artificial streaming, but why may music be getting blocked on TikTok because of copyright at the time of delivery? That could possibly because of TikTok finding some type of match in their system when that content is being delivered, and then blocking it because it may match up to something else, which is a bit out of our control. But if that happens, we do encourage you to communicate that to us and let us know what those issues are so we can help investigate that with you and potentially escalate anything to TikTok if it warrants an escalation there.
Okay.
There will be a recording of this meeting available after we hop off. Laura, who's on this Zoom with us, she will help deliver it and make sure that it is available for y'all to rewatch or for others who weren't able to attend to watch it as well.
Yes, and like I said, we'll be collecting the questions from the chat box to see if there's any reason for us to schedule another one of these, maybe just on the topic of artificial streaming, because I think that was the hot topic today in the chat box. Thank you all for joining us here and for sending over your questions. We've got some additional educational resources here we wanted to point out. Everywhere we've been, like, we always get so much good feedback about our newsletter and our blogs. And I know that the teams working on those here at Symphonic take great care to provide these resources to our clients. And we always appreciate the positive feedback. But we have the blog, we have the help desk. Our support team is pretty nonstop with receiving and trying to process and answer questions or route you to the proper teams internally if there's other team members. And of course, we want to be as helpful as we can. And so if there's other resources that might be helpful, we welcome and we'll consider those suggestions if you want to pass those along. And we do try to offer these resources as much as we can in English, Spanish, and Portuguese, and probably more languages to come in the future. All of our contact information and socials information here, so you can reach out and connect with us there, and also through the email addresses that we have provided during this chat.
All right. Well, thank you all very much for attending. We really appreciate your time today and also your engagement in the chat. I hope that we answered as many of your questions as possible. And for those that we may not have been able to answer today, we're taking note of all of those and we'll consider responding to those on our next webinar.
Thank you
Thanks.
all.